Small Milord, prayer Milord. Item number 17. Can it be taken
Item
up?
number?
17 Milord.
17.
17. Can it be taken up the day after tomorrow, Milord?
Day after tomorrow. Okay.
The-
So I take at the request of Mr. R. Dale and counsel for the petitioner. List this matter again on 6th of November.
I'm appearing for the respondent number 6 in this matter, Your Lordship.
Declare attendance. Yes.
Much of.
Made clear. Because item number 18, man, of hearing.
Huh.
So this matter was parted before Honorable Justice Suman Sham for a long time, Mother.
Huh.
This would require some hearing, Mother. I've taken consent of the other side. Can it be fixed on a fixed date in the month of December, Mother? I need to place some judgments.
2015 matter. Pass it off like that.
Well, in the meantime, Mother, things have proceeded, Mother. The Lordship is aware, Mother, it's the matter regarding rehabilitation of a child, Mother, who lost both his limbs.
Mr. P. Mohan counsel appearing for the petitioner has prayed that this matter may be taken up in the month of December.
On a hearing day, any date, Mother, convenient.
Final disposal. And he has also submitted that there are some developments in the matter which he would like to appease this court after proper instructions. Full stop. Accordingly, list this matter on the 9th of December 2025
Deeply of them.
in the hearing following. Yes.
It is a lordship. In item 6 matter, we had circulated an adjournment slip yesterday.
Item number 6.
6.
An adjournment slip had been circulated in this matter on behalf of the petitioners. And the petitioners
Respondent.
for the respondents with the consent of the petitioner.
Lordship, may I pray for a date? I'm just praying for a date.
What is the matter regarding?
Lordship.
They are claiming a part of forest department's land matter.
Our prayer
That
is
is
for
our
payment
order.
of compensation.
Compensation.
Your Lordship may
Thank
fix in the second, third week of November.
November, we do not know. You
Then
can have it for first or second week of December.
Lord,
In the second week of December on a date to be fixed by the registry.
Lordship is fixing it on second.
Second week of December
Lordship,
on a date. to be fixed.
deeply up.
Yes.
Lordship, I like to mention item number 19, Lordship.
19.
19 is Lordship. My senior, I'm appearing on behalf of Mr. A. Kakoti, Lordship.
Ah.
He's out of station, Lordship, for some medical issues, Lordship.
What about the petitioners? You have informed them? Yes.
We have been duly informed.
What is the matter about?
Lordship, the matter is about contracted use of Hindustan Paper Corporation. The spread Hindustan Paper Corporation.
When do you want it?
Lordship, in the month of December.
On a joint prayer made by the learned counsel for the parties. List this matter again in the second week of December 2025 in the hearing column for disposal. These are all matters we need to finish.
Much of that.
Yes.
Wait, please, Lord. So, subject to item number 12 to 15, my lord. In item number 15, my lord, we are going to file reply
It
today, my
is
lord.
with a width
Yes, my lord.
from 12 to 15.
Yes, my lord. 12 to-
Yes.
In item, my lord, 15, we are going to file
What is the matter about?
matter regarding, my lord, we are the tenant. Accordingly, my lord, our name was deleted by the circle officer. That order was challenged before the Board of Revenue. That petition was allowed in our favor. Then, my lord, the private respondent filed a review. In the review, my lord, review was allowed against us, my lord. Then we have challenged this order, my lord. And that part in the review petition, my lord, initial case was instituted against only one that, 31. But subsequently in the review, my lord, 5, 6 that also included in the.
So what are you, what reply are you giving to what? What is the new
And
fact that has come up
because-
in the affidavit?
Reply, my lord, in item 15, my lord.
Ah,
Actually, this is not the cause of action of the initial petition filed by the
so
respondent.
that is there in a writ petition.
Yes,
That ground is in your repetition. They have answered to that.
Yes.
Why do you need to file an affidavit in reply?
Because they brought some new documents, my lord, that is why we have to reply it.
The entire list almost is mentioned. Oh. Can we wait till the matter reaches more? It's item 12, wait, let us
12 to
see
15.
whether you need to file a reply or not. Just see
Yes.
what is the new document, what is it?
My lord.
Let us also do some work,
Yes,
go home without working, yes. Yeah.
Your Lordship, now the chief engineer has requested, asked the concerned Lordship, divisions Lordship, to submit the first pencil proposals Lordship. Yes.
So they have submitted something, something is working now. Are you
Lordship.
getting provisional pension and all?
Provisional
Yes, yes,
pension
yes,
we are not-
Provisional you are getting.
Yes, Lordship.
Your Lordship, if your Lordship permits me, your Lordship, since the otherwise your Lordship pleading is complete, your Lordship may fix a date, your Lordship, so that matter may be taken up on for final disposal.
Today is not a good day.
No, your Lordship, since I have not prepared, your Lordship, today, since there is an order.
The time period spent by you in a PSU,
PSU.
whether it can be counted for the
For
purpose
purpose of MSCP or not.
or not,
That's it.
settled. Supreme Court settled.
No, your Lordship, so far as that part is concerned, your Lordship,
Hmm,
whether MSCP part probably your Lordship has not been settled, your Lordship.
settled. Getting that case. Man was working in a PSU. Down. Cat allowed. High Court allowed. Supreme Court allowed.
Supreme Court, your
Allowed.
Lordship.
That
I will try
that,
to find out.
that part has to be taken into account. PSUs, you cannot leave it out because you had taken he had taken a no objection, you allowed him to work, you gave him everything else. So if he did not get any promotions in the interregnum, entitled to,
Lordship,
because this is not a promotion.
not a
It's a
promotion.
career advancement
Lordship,
he
yes.
chose.
In view of the, your Lordship stagnancy in your Lordship deposit. That's
Oh, no, the case I'm talking of is pay fixation. Once the pay is fixed, other consequential benefits,
Lordship.
that is how it comes. $211 yesterday,
Started.
huh?
Day before started. Saturday.
Provisionally you are getting.
Provisional.
Provisional pension they are getting. Lordship.
I was
In
under the
fact,
impression that nothing is being done. So you want it in December? When?
In the month of November,
November, we are not there for some time and then
your Lordship
Other
may
lists we
fix
are
as
filling.
per your Lordship's convenience in the month of December.
it has been submitted by Mr. N. Upadhyay and Standing Counsel for the Irrigation Department that the petitioners are being paid the provisional pension as calculated by the department. And the Office of the Chief Engineer Irrigation Assam is taking appropriate steps for calling for fresh pension proposals for the petitioners as per their entitlement without considering their MSCP benefits as of now. Full stop. Mr. S. Bhattakur, and the counsel for the petitioner has submitted that since the pleadings are complete, this matter may be taken up for disposal. Full stop.
9th of December, your Lordship.
Accordingly, list these matters again on the 9th of December 2025, on which date an attempt would be made to dispose the regulations.
oblige Lordship.
Deep level.
Yes, sir.
Can this matter be taken out after some time? Mr. R. Prabhujar is on legs. Otherwise, he will come.
After some time.
Lordship, last time, may have a look at your Lordship's order, my lord.
Run by someone else on your land. Yes.
Lordship's order is there. May I kindly have a look at the order? Lordship handles so many cases a day, may forget, just to refresh, my lord.
Respondent number 1 and 3, sir, you are having.
I am appearing.
Yes.
Although, my lord, I have obtained some instruction
Mm.
regarding running of the RO in the land.
Mm.
I have strong objections regarding maintainability of the writ petition. This is purely a, my lord, suit or rejection. This is a dispute between the petitioner and the private respondent. And
Where the state, where you as the state
I am
has allowed allowed one of your establishments to function and someone to earn out of it.
what
when you
legal
know-
rights of the petitioner, my lord. So there is no constitutional right has been violated. He's not- not-
His
My
land
lord,
is being
there is
used.
interest regarding the, my lord, against the, my lord, private respondent, not to us. My lord, lordship, as per the
It
petroleum.
is your institution. If you move out of there,
My-
if you move your establishment out of there, if
Then-
you stop the illegality part, it becomes a private dispute, no doubt. But with the state's hand in between, allowing that to function.
My lord,
Article 300A, no one shall be deprived of the property except in accordance with law. That is my
And
constitution.
you are giving a license.
that's true, my lord. I am not.
You are giving a license to them on that property.
Because as per the petroleum rules, my lord, we have to provide the, my lord, because until and unless the district administration
Hmm.
is not cancel the NOC.
Which NOC? NOC by whom? NOC was given by whom?
NOC was given as per petroleum rules, my lord, rules 150.
If I can have a copy.
This is the. I don't have the petroleum rules right now, my lord. I have obtained from the. This is the NOC and during the course of NOC, we have to provide the facility.
The district administration has no objection to construction of
Yes.
state in that area.
Yes, my lord.
Where you would keep some explosives, no
Yes.
difficulty. Thing is, if the land belongs to a particular person, you are in the knowledge that it is being used by someone else. The state allows the illegality to go on.
My lord, the the partner who, my lord, given assurance that there are some,
Take him to court.
yes, they
Take him to court.
they approached the IOCL authority to continue because there is a provision for reconstitution of dealership. It is a
Mr. Sharma,
temporary arrangement, right?
Mr.
Temporary-
Mr. Sharma,
My-
let me put it this way.
Fine.
We have other standing councils for the corporation.
Yes,
Now, suppose I ask someone for you to move out and him to take over the brief right now and do the things. Not proper. It is your brief. It is his land. Someone else gives an NOC. Someone else enters into an agreement with you. What is the right of the IOC to continue supplying oil to a location where the owner stands up to say that it is my land, please stop it. And the person with whom you are having a business deal has nothing to show that he has some authority to let you use the land.
we have given the notice to the persons who are running the petrol pump. Our relationship with the dealers and the IOCL, the.
So you move everything
petitioner
that
is
you
the
have,
third person.
you move everything that you have inside that premises, you move it out.
And if, my lord, they fail to, my lord, renew the, my lord, lease agreement.
And
then
what about the time
we
that
we have to remove it, but
there is,
Lordship may kindly see the section 150 of the petroleum rules. I read it slowly, my lord. I have that particular page only printout. I have taken from the, my lord, soft copy. A no objection certificate granted under Rule 144
Hmm.
shall be liable to be cancelled by the district authority
or the state government. If the district authority or the state government is satisfied that the license is ceased to have any right to use the site for storing petroleum, provided that before cancelling no objection certificate, the licensee shall be given a reasonable opportunity of being heard. And on the basis of that, my lord, the district authority or a state government cancelling a no
Can we have
objection.
a look at the prayer made in the writ petition?
That is why, my lord, I have that objection of regarding maintainability. Prayer A says 9.
Hmm.
A writ nature of mandamus shall not be issued directing the respondent authority in the IOCL to immediately suspend, stop, shift the operation of the petrol pump operating under the name and style of MS Purnima filling station, which is being operated from the land belongs to the petitioner. Number one. Second prayer is, in the nature of mandamus shall not be issued directing the respondent in the India Oil Corporation Limited
Now,
to remove.
this vending and pumping paraphernalia, that belongs to the IOC.
Yes.
It is standing on a land belonging to the petitioner. On record, IOC is not bringing anything before this court to show that we can doubt his ownership on the land. Your things are standing on his land.
Our, my lord, machinery only,
Remove them. Remove whatever you have from his land.
my lord,
We close the writ. We say
I leave it to the lordship. I leave it to the lordship, but I have still, my lord, objection regarding the maintenance of the suit. But I leave it to
the maintainability of the writ petition.
because, my lord,
what
should my lord,
what is your what is the issue that you say that this court cannot go into?
this is a disputed question of fact between
Which-
the petitioner and the private respondent
Which is a
regarding the land, and the petitioner is failed to, my
We
lord,
totally-
failed to eject them.
We will totally
My-
agree with you, Mr. Sharma,
My-
that his right over the land vis-a-vis the private respondent.
My-
If that is a question, if that is a question anywhere which has been raised by any of the parties,
My lord.
we will wash our hands of it. Every party is admitting that we are not the owners of the land. The private respondents are trying to say that we are in a partnership over which there was a lawful business because someone in his family had allowed the user of the land. That person dies, rights are with someone else. There is no furtherance of any agreement from the petitioner to let anybody use the land. That is not disputed.
Right.
Again, what remains undisputed is the Indian Oil Corporation knows that the person who is running that petrol pump does not have any right over the land. You know that.
So far land is concerned.
So far land is concerned. It is not in dispute that the IOC, knowing this, is using the land to put up their machineries to make an income out of it. Supplying of petrol under the essential commodities or whichever act. That is another part. The moment there is a scarcity, district administration will take over. We do not doubt that. But as of now, a private piece of land over which IOC has got nothing to do has all its machineries there. We kept it as a part, and we kept it today so that the IOC can make some arrangement by which they can wash their hands of the issue. The state can be out of this. The moment the state is out of this, the writ court is out of this. And if it is the stand of the IOC that whether the land belongs to someone or not, we have our machineries, we will run the show. That is short of saying that we want to use the land, we will barge into it. At this moment, are you not illegal occupants on the land?
My lord, the practice of the supplying of the pilot.
That will not legalize.
This type of problems always happen, my lord. Always happen. We give some time to the dealer to.
If I'm not wrong, the person expired, Mukul Bodolo expired 2020.
5 years ago.
5 years. 5 years you have been given someone time. Writ petition filed in 2020.
Yes.
Still giving time.
Yes, my lord, we are the government of India undertaking, we always think the commercial
Even
interest of
when,
the corporation.
even when the
Apart
state,
from the, we have to, my lord.
even when the state or the union has put up offices in the land of private individuals without giving them compensation. That is what we have seen in a few cases. Supreme Court has allowed so many things to them. You are not allowing someone to use their own land. He is before the court for the last 5 years. Today your stand is he should fight with his sister-in-law, brother-in-law, whosoever it be. But your things will remain on the land. Can it be? Is it not the first
They
step
may-
of the state to say hands off?
My humble
We
submission.
will not be
before-
there.
Before your lordship, my lord. They may approach the appropriate authority to remove, my lord, to get back the land and to remove the.
They have already approached. I don't think we are an inappropriate authority to direct you. Are we inappropriate, sir?
My lord.
Would we
the
be
writ court, my
inappropriate to say
lord.
that that the petitioner has a right over the land?
Read court, my lord.
You could not show anything.
Read court, I have, my lord.
When you have not disputed, had there been one sentence of dispute,
That.
we'll give you
that
time
is-
till-
That is undisputed.
we will give you time till 2 o'clock. Show us that yes, we have raised a dispute here. We do not admit that part of
That I don't.
in that case. When we don't need to take evidence,
There is no.
when
need
everything
to-
is there on
There
record,
is no need to go to 2 p.m. my lord.
when everything else is on record, when nothing is disputed, when we don't need to take evidence, we don't need to appreciate it.
Acts of the case is undisputed.
So
There
you
is
are
no-
there unauthorizedly.
Since my lord, district administration also did not, they did not approach the district administration for cancellation of the NOC. my lord.
District administration is not
We approach.
on your land.
And if they approach, my lord, district administration is not doing anything. Till my lord, district administration's NOC is there, we used to, my lord, supply that. This is my humble.
There is an English saying called pass the buck. You are trying to send the
Page
buck to
53.
someone else.
Page
They,
53.
only if they cancel it, then we will cancel it. No. You
Regarding-
show us how come your machineries are on that part of the land where a specific stand has been taken that there is no authority for that private respondent to have allowed you to do so.
Suppose, my lord, one question I put myself, my lord. If, my lord, tomorrow we remove our machinery from the plot of land and we stop the supply, can they take over the land without approaching the, my lord, civil court?
That is their problem.
This is the problem.
That is their problem.
This is the problem.
That is their problem, not your problem. How they want to use the land, how they get the user of the land is their problem. But till the time you are there, they are neither here nor there.
They trying to pressurize the.
It is like saying that yes,
Instead
we
of
admit the
my-
land is yours, the records are yours, everything is yours. Just go and prove it in the court. Where does it lead?
I leave it to your object, my lord. This is tax is not disputed. My lord. My
Who appears
submission
from the
is,
private
since my
respondent?
lord, district administration has not yet cancelled the NOC, we are supplying the, my lord. Well. to
You have
the-
filed your affidavit.
I have filed. Our stand is, my lord, regarding maintaining.
Your stand is regarding maintainability.
Tax are admitted. Tax are admitted.
But rest of it is admitted.
Tax, my lord.
And maintainability, where do you say that?
Paragraphs 6, 7, 9, and 10.
Paragraph 6, you do not say so. Paragraph 7, you do. You are for 1, 2, and 3.
1, 2, and 3.
6 and 7, you don't say so.
9, my lord, 9 and 10.
Petitioner raised some disputed question of fact. Can you just show us the disputed question, whichever they are in the writ petition? That this is in dispute.
My lord, regarding my lord land, this is.
Show us.
So far the, my lord, retail outlet is concerned, that is undisputed. So far, my lord, lands are concerned, there are some dispute between them, my lord.
Where do we find that dispute? You say it is in the writ petition. Where do we find it? If there is a dispute, none the happier. We write less. No dispute. Then.
Paragraph 3, my lord. Second line. Upon being assured by Sri Mukul Border that he would use the said land by himself only for a purpose of retail and to petrol diesel on the basis of the IOC LOI issued by the IOCL. The petitioner agreed to give the said plot of land on lease to Mukul Bordoloi for a period of 20 years. However, the said lease deed was never registered in spite of multiple requests from the petitioner. These are the disputes between them, my lord.
What?
Then, my lord, paragraph 4, general power of attorney dated to ensure the petitioner and his brother Sri Girin Das were appointed as the lawful attorney of the LOI holder Sri Mukul Bordoloi for the purpose of setting up petrol pump. As a result, the effort of the petitioner, the pump was set up under the name and style of MS Purnima Filling Station and was successfully operated by Mukul Bordoloi. On the basis of the LOI and the lease deed of Mukul Bordoloi was issued, to ensure.
Yes,
They
we'll
said-
keep this for Thursday.
I'll-
Would it be difficult if you put in your written arguments so that we can incorporate everything that you'd like to say? We might miss out a sentence here and there if we now start dictating. So put down everything you want to in your written argument. Let it be on Thursday. As short as possible. We just need to be reminded what you would like to be taken note of.
Friday.
Similarly,
Friday.
let it be Thursday, sir. Because Friday, after Friday, I may not be available. Thursday, if you give it to us, we'll try to have it delivered on Friday. Yes, in short. And who appears for the private respondent? None.
They are not.
7 is the private respondent. Yes, what do you have to say, madam? Without hearing you, we should not close. Yes. You have filed the affidavit. You want to add up anything to it? Kindly, you want to. You have supported the petitioner. What about the person who's running the pump right now? We do not.
We do not.
Mosumi Khan Das and Parasmani Das?
Yes.
Have they been served?
They filed the affidavit.
But none appears for them now. Last occasion also perhaps none appeared.
Last occasion, I think major response number 7 was not.
No, none appears on behalf of 5 and 6. Although affidavits have been. Yes. Heard Mr. A.C. Borbora, learned senior counsel appearing for the learned senior counsel assisted by Mr. So-and-so learned counsel appearing for the petitioner. Mr. Borbora had made his submissions on 17-10-2025 also, which has been recorded in the order dated 17-10-2025. And today the matter was fixed for the respondents, counsel for the respondents number 1, 2, and 3 to answer the queries raised by this court on that day. Today, Mr. D.K. Sharma has appeared for the respondent numbers 1, 2, and 3.
5 minutes, 7.
And he has submitted that apart from the stand taken in the affidavit in opposition regarding the maintainability of the writ petition, the fact also remains that the no objection certificate issued by the Deputy Commissioner Morigaon on 9/6/2015 for establishment of the retail outlet shop. We call it a retail outlet. A retail outlet of the Indian Oil Corporation has not been revoked till date, and therefore the IOC continues to have a right to have the outlet
Supplying the
functioning there, supply to have the outlet there to continue to supply fuel. Stop.
Respondent 7 has filed an affidavit.
The
Respondent 7 means my dead brother, we were the joint co-owners of the land, right title holders. He died. Your wife is filing, supporting.
No, this
Substitute.
Girin Das is expired.
Initially, my lord, that was also my lord,
No.
my lord,
My lord,
regarding maintainability.
Respondent
It did
seven.
not, my lord, arrest her as party respondent.
respondent 7 has.
Whom?
My lord, the respondent number seven.
No, she has filed an affidavit.
Subsequently,
Where is your affidavit? Your affidavit for respondent number 7, where is it?
Where is it?
Like, yes, we find it. R7, but
Endorsing the petitioners.
no, but that affidavit, we have to discard, Mr. Porpora, because if you see, starts with the sentence, I, Srimati Moina Das, I am the respondent number 7, she is not. Girin Das is.
There was a I
Substituted. There
There is a substitution.
was an IF file already substituted.
That was also amended cost title has come.
Paragraph number 3 and
Amended cost title has come. Yes, Mr. Sharma.
He died.
7 substituted
seven, sir.
and 7 has filed an affidavit.
So as per procedure.
So I think that affidavit we can take on record now.
My lord, that can be.
Respondent number 7 has also filed an affidavit in opposition, and it has been stated by the Learned Council appearing for the respondent number 7 that the stand of the petitioner in the writ petition is supported by the respondent number 7. List of respondent number 5 and 6 who have filed their affidavit, go unrepresented today also. List of list this matter again on the 6th of November 2025, allowing the counsels for the petitioner to submit their written arguments. Should we list it? or not?
Written argument, if necessary, I will file my lord, but I have submitted.
No, let it be on the 6th, because whatever I have written down in the order is okay. Then while dictating the order or while formulating the order, we sometimes miss. So a written argument from your side, not the full detailed argument. These are the points you want
Just
to
jot
raise.
downing.
That helps. So we'll keep it on the 6th. We are keeping it on the 6th.
Definitely.
Only for submission of those written arguments, we'll deliver the.
Okay.
List the matter again on 6/11/2025 for allowing the councils to place their written arguments before this court.
So
Any
Thursday we,
judgments you want to refer to, anything you want,
Thursday we only placed,
maintainability, if you want to put in something, just put.
Thursday only we placed the written
Yes,
argument.
yes.
No hearing.
No, nothing.
Obliged, my lord. My,
We conclude the hearing.
that may be recorded.
Only for submission of.
The hearing of the parties have been concluded.
No,
I'll arrange the sentences you just said.
obliged, obliged. Lord.
Yes, madam.
This case is relating to releasing of the subsidy of the part amount.
Ah.
Partly they have released. A scheme was announced in the year 2007.
Respondents, ready. We are taking it up.
Still there, I don't know whether Mr. Gowers, every day somebody else.
Madam,
will be
let him
appearing.
say whether he is ready or not, then we will decide whether somebody is ready. Let's continue.
Yes, ma'am.
Yes.
So Central Capital scheme was announced, Central Capital Investment Subsidy Scheme 2007.
Yes.
In short, it's called NEIIPP 2007.
Hmm.
It is in my lord Annexure 1, page
27.
Annexure 1, page 27.
Hmm.
So my lord, first paragraph I'm reading. Notification in pursuance of the Northeast Industrial and Investment Promotion Policy 2007, so and so, Commercial and Industry Department, Industrial Policy Promotion, Bhai Memo Number Iman and year, April 1 to 2007, the Government of India is pleased to make the following scheme of capital investment subsidy for industrial units in the Northeastern region comprising of the states of so and so, all the states, including Tripura, with a view to accelerating the industrial development in the NER.
Hmm.
This scheme is called Central Capital Investment Subsidy Scheme 2007. Commencement and duration, it will come into effect on 1st of April 2007, remain in force up to inclusive 31st of March 2017. Applicability. New industry. These are decided, my lord, because the first time he has approached the honorable court for not releasing the subsidy in 2008. That was the first writ petition. Thereafter, that writ petition continues. That writ petition continues
Do we
for
have that
several
order
times.
or past in the
Order,
petition?
yes. Annexure 5, page 40,
Page 40,
40, my lord.
40.
Yes.
Yes, what did it finally say?
Yeah, my lord, that his number is at second one. First one is Issuer Food Product, second one Vision Ispat Private Limited. So, my lord, Honorable Justice, then the order, pass the order, 5/10/2013, page 41. If bunch of 4 or 5 petitions were decided together, my lord. And my lord, lastly, the direction was given in page 51, my lord, that in such circumstances and following the discussions made above, court is of the view that refusal of the respondents to release the already approved CCIS amounts to the petitioners is not justified. Accordingly, respondents are directed to release the admissible CCIS amounts to the petitioners within a period of 2 months from the date of receipt of the certificate copy of this order. So, writ petition was allowed. Thereafter, they went on appeal, my lord. They have challenged this order. That is, my lord, in next page, page 52. On 3/3/2014, it was decided the matter was remanded to the single bench to hear it again.
Yes.
Last direction was my lord. Page given not here. Direction was it at my lord, page 56. Here, my lord, the division bench that accordingly and in the light of the foregoing discussion, the appeal succeeds and is allowed in part. The impugn orders passed in repetition, out of which these appeals arise are questioned.
Sorry to interrupt, madam. This matter pertains to Industries Department. My lord, now the councils are not there, my lord. So it has been, my lord, handed over to the government. I have got the file, my lord, now. Can it be on Tuesday or so, my lord? Coming Tuesday.
Already 4 councils have appeared, my lord, on different. Dipankar also,
Yes.
then last Gogoi.
No,
and
I have not
Tara
appeared
Gisa.
on the.
You have not appeared, but
No, I will take
every
over the lordship.
every day new faces.
Yet, my lord, I will appear.
Every
He
new
assures that
faces.
on a fixed date.
Yes.
It was
He will not
listed
allow-
before court number 10. There also appeared 2 advocates appeared on different occasions, taking time. Now last occasion, Mr. K. Gogoi appeared. Now we'll have
No,
Mr.
lordship will give a
Gogoi.
fixed date, I will, my lord.
Let it be on
Just-
Thursday, my lord.
Thursday.
How long I will wait and prepare, my lord?
Huh?
Personal difficulty on Thursday and Friday, any day, my lord, next week.
Next Tuesday. Next Tuesday. But every day I will prepare and go home empty my house. Because 4 councils have.
Yes, that much of
already-
course can also be there. You can ask the council.
11th or, my lord, on 13th.
Tuesday, yeah, no, to November. Let it be on 11 November, my lord, Tuesday, 11 November.
11, I have some parts of it. Can it be on?
Then, my
13
lord.
also?
October 13. ঠিক আছে তোমাৰ 13 ঠিক আছে মইহে মানে মোৰ বস্তুৱে হেৰাই গ'ল ডাঙৰতে গোটে খাইতে হেৰাই গ'ল এটা মান শব্দটো There's happening, my lord, that can I submit my part, my lord? He will reply on 11. তোমাৰ কি comment আছে কৈ দিয়া।
11th, we will not be here, so
When you will be here?
and by the time we come back, we might forget.
Next week, your lordship will not be there.
Possibly not. So
The case is not lucky enough because it is fighting from, they got part amount, my lord. October 14th,
Proceeds
they-
applies in
but the rest of the amount, they are fighting, still fighting.
27th 27th of November is comfortable?
তাৰ আগত আছে নেকি? মোৰ মানে 28
No, তাৰ আগত
There is a function, my lord.
before
Their
that, on
ancestors-
27.
Ancestors Sadda is there, 28, 28.
Then it can be
26, 26, my lord, Tuesday,
26th is a Wednesday, man.
Wednesday নেকি? Okay, okay, 25th. 25th will be convenient. আগদিনা যোগাৰ টোগাৰ কৰিব লাগেতো। 25th.
On the prayer of Mr. B. Gogoi, list this matter again on 25th of November 2025. Stop. Miss N. Saikia, counsel appearing for the petitioner, has submitted that the matter is pending from the year 2021 and relates to payment of subsidy, of which already a part had been paid and a part has not been paid. List as directed before. You've taken down your submission, the 5th. Hearing the reserve.
Well, it may be taken after some time.
Ah,
Senior counsel is late in court number 7.
this is, what was this matter? Salary account,
Salary account.
stopping of that account. You are required to have some instructions.
Yes, my lord, we have got instruction, but senior counsel is late.
You have the instructions?
Yes.
Upon piece of paper. Some instructions, sir?
The petitioner died, my lord. So they have filed, I think, interlocutory application for substitution, my lord. The first, my lord, it is required to be substituted, my lord.
Very
He
well,
died
but
in
we
the-
just want to know whether the department is cooperating with you in giving you the instructions, or
My
do we
lord,
need to
My lord, my lord,
inform them that they should give the instructions?
my lord,
That is,
my lord, regarding instruction is
Yes.
yes, my lord. The village is of the non-cadastral village, my lord. And the petitioner has not yet submitted any application for demarcation of the land, my lord. So the land, as per the revenue record, my lord, settlement records, my lord, land is in the name of the petition. As it is a, my lord, non-cadastral village, my lord, and the soil conservation has constructed the land in the, as per the, my lord, the telephonic instruction, on the land of their own, my lord. So whether the land of the petitioner where the
Has
ID
been
is
used,
constructed, my
utilized
lord,
by
used
the-
not, my lord, that is required to be inquired into, my lord, by your joint inspection like that, my lord. And petitioner and the official has already visited the house of the petitioner so that it can be jointly, can be inspected, my lord. That's the verbal telephonic instruction. Lordship may first substitute the petition. And he died in the year 2024, my lord.
there is one judgment of the Supreme Court which says the moment an IA is filed,
On 10/4,
the abatement
2024.
goes.
10
The moment the IA is filed, the abatement goes, there is no question of delay in a rate.
My lord, 10, but the lordship passed the order on 27/10/2025,
Ah.
but the petitioner died on 10/4/2024. So substitution, my
Do you
lord,
have any objections to the petitioner being substituted?
my lord, lordship will look into it whether there is a period of limitation of filing the substitution petition.
Sometime in,
Lordship may, discretionary power is there, whether lordship may exercise the
what
discretion.
was that case name? Supreme Court, it was very clear saying that its limitation part will not come when you substitute it in a writ petition.
I'm not objecting it. That's why.
So let us just substitute it.
My
that
lord,
You file
my
the
lord,
amended
lordship
cost
may
item.
substitute it.
I have filed the interlocutory application.
So we'll allow it. Thereafter, you have to file the
My
amended
first
cost
item, my
item.
lord.
Then we can take up the matter. In the meantime, if
My
you
lord,
can
we'll
file
file
your
the-
affidavit in opposition so that on the next
My
week, we can take
my-
up some call.
My lord.
This is in IH civil number 3417 of 202. This interlocutory application has been filed by the wife of the petitioner.
Wife of the.
Wife of the petitioner
Was not served to us,
in
my lord.
WPC number.
But copy was not served to us, my lord. But just I'm saying, my lord, when our official visited the house of the petitioner, my lord, the wife said that she has not approached the court, my lord. So at least they have to serve us the copy so that I can take the instruction whether the petitioner wife has already filed the petition or not, my lord. That is, my lord, so I cannot submit it, my lord, else the copy has not yet been served to us, my lord.
As it is required, before filing, that necessary part.
PR Mohanto SC Revenue received it. বাইদেউ মই মাজতে কৈছিলো যে unless pleadings are signed by all of the parties concerned, pleading to accept কৰিব নালাগে. Now this has again been accepted on 23/10/2002. এইটোতো মই এবাৰ কোৰ্টত মাতি লিখাই কৈছো নাই কৈছে আজি কৈছে নাছিলে I had asked the court, do we need a judicial order? Registry upon close to এখন লাগি যাব That's a judicial order saying that despite instructions, this is being repeated.
Let a copy be served to us, my lord, so that I can take the instruction on that also, my lord, whether it is genuinely filed or not.
Yeah, you take down. This interlocutory application has been filed by the wife of the petitioner from our submitting that the petitioner has had expired during pendency of the writ petition, and therefore the names of the applicant number 1, 2, and 3, who are the wife and the children respectively of the petitioner in the writ petition needs to be substituted in place of the petitioner. When the matter was taken up for consideration, Mr. J. Kia Learned Counsel appearing for the KAAC and so appearing for, you are appearing for?
Respondent number 3, man.
Who is the respondent number 3? DC, the Deputy Commissioner of Karbi Anglong have submitted that they are yet to be supplied copies of the interlocutory application. Perusal of the record shows that the copies of the interlocutory application had been supplied, had been received by the Standing Council Revenue, and there is no proof of supply of copies of the application to the other respondents appearing in the writ petition. The Learned Counsel for the petitioner oblique applicant, a writ petitioner oblique applicant in this application has undertaken to serve a copy of the interlocutory applications on the councils, on all the councils, appearing for all the parties within a period of 2 working days. Stop. List these matters again on and after 2 weeks on a date to be fixed by the registry for consideration of the interlocutory application. We'll take it up after you get a copy, but otherwise I think there's some judgment of the Supreme Court which says that in these type of cases,
There's some other.
can be allowed.
Some other points are also there. I will argue on that point also.
We'll allow the substitution to happen.
No, but at that time I will argue, my lord. At that time I will argue.
Deeply obliged.
Yes, Mr. Krishna.
The case of the petitioner is that, my lord. They received notice from the tax department claiming that they are under Karbi Anglong district, my lord. Under Karbi Anglong district, my lord. But facts remain.
No, last time I think
They produced one judgment of the honorable court.
yes.
This honorable court. That's a different matter, my lord. But here, my lord, kindly consider one thing, my lord. Here, my lord, there is absolutely no dispute raised by the revenue Revenue Department,
No, that,
not the Deputy Commissioner.
what we are trying to say is
My lord,
perhaps
my lord.
to cut a long story short, perhaps without the respondents first being giving you a notice, they had given you a notice saying that you are on their land. You must
My
have
lord.
responded to it.
My lord,
That has to be decided.
my lord.
Without deciding that, they can do nothing. They cannot impose tax on you. If you have raised that ground, where is your reply to that notice? Can we have a look at the notice?
Yes, my lord. The
We are not
notice-
going into the
notice-
other.
Notice at page 16.
We are not going into that judgment part now because you are disputing it. We will not say it is covered. We will
Fine.
try to decide this.
My lord. My lord,
16 is the notice, yes.
16 is the notice.
Without obtaining trading license from KSC authority, which is violation of section 3 of the Karbi Anglong. Now, where is your reply to this?
My lord, we filed application before the Deputy Commissioner.
Where is it?
Page 62. Page 62, my lord.
Thereafter, what happened?
My lord, before that, my lord, kindly consider paragraph 3, my lord.
Of
My read petition, my lord.
your read petition. Yes.
My lord, since inception of Mickey Reels,
But
my lord,
writing pad এখন দিও না। Huh?
since inception of creation of Mickey Hills, my lord, in 1951, my lord, under the Mickey Hills District Trading of Non-Tribal Regulation 1953, my lord, there is no dispute, my lord, as such that we are falls under Assam, my lord. We are giving our vote within the state, my lord, and we are giving our tax to the local authority, my lord. Kindly consider the tax certificates, page 50.
See, 50.
50, my lord.
Yes.
In our village, the police outpost is also there. This is the certificate, my lord. Certificate is accepted for the year 2022, dated 3/8/2022 to 2/8/23 from so-and-so, son of so-and-so, resident of Maisam Mauja Gorubat, PS Kochua.
Yes, we are
My
visiting that. Yes.
My lord, even the Deputy Commissioner of Karbi Anglong never said that this village is under the jurisdiction of Karbi Anglong. But for the first time in 2023, the taxation department, who is under the Commissioner of Tax State of Assam, they are raising this dispute.
Where is it? Notices?
That notification was issued by the taxation department. Madam.
Karbi Anglong Autonomous Council has given you that notice.
Superintendent of Taxes.
Karbi Anglong Autonomous Council is doing it. It is not being done by this fellow.
Correction, my lord.
It is being done by Karbi Anglong Autonomous Council.
But till 23, no dispute.
Very good. Now, once you get a notice from some authority, correctly, incorrectly, whether that authority has a jurisdiction or not, would you be first required to reply to that notice, raising that issue?
My lord.
That issue is not here before.
My lord.
That reply.
That part is there.
That reply to the notice had not gone. So an application was given to the Deputy Commissioner.
Deputy Commissioner Nogam.
And now there is an affidavit filed by the Karbi Anglong Autonomous Council.
My lord.
Their stand is that, do you say it was, Mr. Sutia, do you say it is It is within your territories
my
that
lord,
they are
we have-
functioning.
My lord, we have already, my lord, annexed the notification issued in the year 1950, demarcated the boundary of Karbi Anglong Autonomous Council.
Okay.
We have, and our specific stand that the area is within the within the jurisdiction of Karbi Anglong Autonomous
Now,
Council.
whether that area falls within the Karbi
Yes, my
Anglong
lord, yes, my lord. We have
Autonomous
issued an,
Council or not,
yes, my
that
lord.
has to be done.
That is a disputed question of fact, my lord. And if you lordship look into the Article 244 of the Constitution first.
Yeah, bye.
That is the only power we are seeing here. 244.
Article
How does it
244.
help you?
Administration of scheduled areas and tribal areas. Two, my lord. The provisions of the sixth schedule shall apply to the administration of the tribal areas in the state of Assam.
Your authority to administer anything within
Tri-
your
tribal
territorial
areas, right.
council is
So, my lord.
undisputed.
My lord, then my lord,
The
lordship.
only issue that remains
My
to
lord,
be
lordship
sorted
can look
out.
into my lord, sixth schedule then, my lord.
Yes.
Sixth schedule, my lord. Paragraph 1(3), my lord. Paragraph 1(3).
That one pages.
My lord, 3, the governor may by
Just a
public
minute,
notification.
209. Just a minute. Yes.
The governor may by public notification include any area, any of the parts of the said table, exclude any area from the said table, create, then diminish the area of any autonomous district, increase the area of an autonomous district. Next, G, define the boundaries of any autonomous districts, provided that no order shall be made by the governor under clause C, D, E, and F of this subparagraph, except after consideration of the report of a commission appointed under subparagraph 1 of paragraph 14 of this schedule. Then lordship will look into paragraph 14, my lord.
Of?
Of sixth schedule, my lord. Paragraph 14. Let's get.
Yes.
Appointment of commission to inquire into and report on the administration of an autonomous districts and autonomous region. The governor may at any time appoint a commission to examine and report on any matter specified by him relating to the administration of the autonomous districts and autonomous regions in the state, including matters specified in clause C, D, E, and F of subparagraph 3 of paragraph 1 of this schedule, or may appoint a commission to inquire into and report from time to time on the administration of autonomous districts and autonomous regions in the state, generally and in particular so and so.
Now,
accordingly,
the last
government
date you had submitted
Yes,
that
my
this
lord.
commission has come
Accordingly,
into existence.
My lord, accordingly, government has constituted a committee, my lord. A commission has already been constituted. I have
Kindly-
already furnished it to my lord and to the learned friend also, my lord.
I have to say that is not available here on, no, it is not here. So,
My lord, on
can you
my
give us
lord,
another copy?
April, my lord, on 29th April 2025, my lord. And that was furnished to the in the earlier occasion, my lord, when the matter was heard by the court, my lord. I furnished
24th.
29/4/2025. And on that basis, my lord, some other cases has already been disposed of, my lord. That was also placed before your lordship. My lord.
That is what we have said in the last order.
Order, my
also,
lord. My lord.
that this is the commission which will hold that
My lord,
to public
my lord,
notice
we
invite.
have no objection to go there. At least they have to show that these villagers belong to Karbi Anglong. my lord.
We have annexed the my
That-
lord, notification of
that-
1950.
Right from they are claiming. my lord.
That issue, see, the notices would be kept in abeyance.
My
We
lord,
can set aside the notices also,
my lord.
but the liberty would be up to the KAC to issue notices or collect access from you if the place where you are running your business comes out to be under their region.
My lord.
You're paying someone X for in the past is not
My
going to help you then.
My lord, but the facts remain that even the
That is what the
outpost-
commission will find out. That fact
Right.
finding will be done by the commission.
Okay,
We will not do it.
okay, my lord. Right.
You have that judgment, sir.
Yes, yes.
The similar cases which
My
are
lord.
disposed of.
My lord.
Have a look at that. What happened to the notices there?
My lord, if,
Yeah.
my lord, the council have the power to issue notice
Uh-huh.
within the jurisdiction, my lord. So the, my lord, before setting aside the notice, my lord, it is required to be come to a conclusion that the area is not within the autonomous council and we have no jurisdiction. My lord, that finding before, my lord, was setting aside that particular notification notice, that it is required to be come to a conclusion that the area is not within the autonomous council, my lord. And we have, my lord, under paragraph 12, my lord, we have the power to enact the law. Accordingly, we have the enacted law regarding, my lord.
We are,
And the paragraph 12 says that,
he is not disputing any of those.
my lord.
All that he's saying is that my area where
My
I
lord,
live
whether
is
that
Yes,
is not, my
falling
lord,
that area.
whether that question, my
That
lord,
is
that
simple
is
thing.
required to be decided by the commission, not by the honorable court.
It is
And
being
a
decided by the
disputed question
commission,
of-
we agree to that. But
So-
till the time the decision comes,
My lord, it is his duty, my lord, duty of the petitioner to approach the commission that this area would,
so now that he has come up with the dispute before this court,
my lord. So the
And it
dispute
is
is
your
required to be
submission
referred to,
that-
my
that the
submission is that dispute is required to be referred to the commission.
commission, and the question of the court is, what happens to the notices which have already been served to?
My lord, that,
What happens to them?
my lord, that notice will prevail, my lord, as long as that disputed question of fact has not been decided by the commission. That is by submission, my lord. So if you lordship,
My lord,
lordship may grant me time to file the written argument then, my lord. I'll submit a written argument, my lord, on that.
my lord,
I'll submit
we
it
are,
by
we
Tuesday,
are
Thursday.
paying tax to some other authority.
The
Admittedly, we are not
My-
adhering any tax.
My lord, government will
who
say, my lord,
appears-
also regarding, my lord.
Who appears for the deputy commissioner in this case? Yes.
My lord, I
Now
would say,
an-
my lord, that Deputy Commissioner Karbi Along, District Commissioner, Deputy Commissioner Karbi Along cannot decide the issue regarding the territorial jurisdiction.
Very true.
District Commissioner Naga or cannot decide the issue of territorial
Now-
jurisdiction, as it is only by the commission appointed by the governor can only decide the issue.
We'll keep that in mind. Yes, they had made an application to you saying that we fall under the jurisdiction of Assam. Huh? How long, madam? It has come. Is there a shortage of carriers of instructions in the government? We can arrange. We can arrange for people to be coming here with instructions. From 2023 notices issued. It's Mr. Gogoi, you are also required to take some instruction
but
in
my instruction is
2023.
very clear. Otherwise, my lord, we will collect tax, professional tax or whatever be.
Hmm?
We will collect tax from the tax department. Only in those areas which are outside the territorial
Anglong?
jurisdiction of Karbi Anglong.
So now you have already collected taxes,
Now, that part, my lord,
apparently.
no, that part we have clarified. But my lord, if after this verification, if it comes up, that it is within the.
So
territorial
till now,
jurisdiction,
as of today, your
or also
collection,
it is
your
disputed part now.
your collecting of taxes
Yes, we have the right.
from the petitioner
With the
will
impression,
perhaps indicate that you think that the petitioners are not within the KAC limits. Because you have collected it from them.
yes.
You would
Yes,
not have
yes,
collected if it is within KAC. You have collected.
Yes, ma'am.
So your stand would be that yes, they would, they
No,
are
that we are
within.
not saying, my lord,
No, no.
since the dispute is now been raised, my lord, we cannot, maybe, my lord, under the impression, we have issued a notice. But that part, of course, my lord, because lordship may kindly peruse by instruction, very. Technically, they have written it. That's the whole issue, my lord.
Where is that letter where you say paid taxes, professional tax to Assam? You showed me some document.
Page 50, my lord.
Page 55.
8 minus 50.
50. Whom did you pay it to?
Panchayat. my lord.
Panchayat, this is not to the this is
My
the
lord, no.
professional tax paid to
No,
them.
no.
Now you paid a tax to Panchayat, they took it.
My-
They are not coming up to say that you are within their territorial jurisdiction.
my lord,
Deputy Commissioner still wants time from 2023. You are under some protection of this court. No,
No, my lord.
and you are not paying the tax also.
No, we are paying to the authority, the Panchayat, my lord. It is not that we are evading tax.
Hmm. You want to pay to the appropriate person. So why don't you stop paying to the Panchayat and start paying them? Entire issue closes.
My lord, no, my lord. They
Then
are,
Panchayat will come after.
they are invoking power under Mickey Hills Act. My lord. Mickey Hills regulation and their regulation number 3 says that control of trading by non-tribal. No
The
person.
difficulty in this case is we could have disposed it of, but we have not even filed a reply to the notice.
My lord. That part
To
is
the
there.
case
Admitted.
saying that we are
my
not
lord.
supposed to pay to you. Then they would have made an order
My lord.
that you're falls within this boundary.
My lord.
Then things would have been different. Now we
My
don't
lord,
have an order which we can interfere with.
My lord, let the instruction come from the deputy commissioner, my lord.
Saying what?
Regarding the
Not the authority. Under the law in 6th schedule, not the authority. Deputy commissioner cannot say it has to be that commission or it has to be the orders of the governor.
we are agreeing to go to the commission, my lord.
What
As
we
per
can
that-
do is we
that-
can
as
give
per
you,
that
we can
notification,
give
my
you the liberty to reply to the notice.
My lord.
We can give you the liberty to go before the commission with your
My-
grievances saying that
my-
whether this land falls or not.
My lord.
And till the time they consider your notice and let you know in so many words, till that point of time, the notices may be kept in abeyance.
My lord. That will
Once they let you know why they say you are under their area, then you pay the concerned authority, either the panchayat or them, whoever is the authority. And in the meantime, the commission will come up with some
My lord.
report. You can approach the commission also.
My lord. We'll
Yes.
see that.
So we'll dispose it off. Yes, take down. Heard Mr. G. Bushel and the council appearing for the petitioner, also heard Mr. Gator and the council appearing for the Karbi Anglong Autonomous Council as their standing council. Mr. B. Gogoi appears for the Department of Taxes.
My
Ms. So appears for, Ms. Burman appears for the respondent number 6. The petitioners have raised a grievance in this petition regarding the notices issued.
Before Lordship pass the judgment, my lord. One point is I have to argue, my lord, that the Karbi Anglong Autonomous Council is constituted under the 6th schedule to the Constitution of India.
True.
And the Karbi Anglong Autonomous Council is the authority. In the repetition, Karbi Anglong Autonomous Council is not added as a respondent, so petition is not maintainable.
So how on what basis did you appeal?
Lordship will look into my lord. I'm appearing on behalf of the principal secretary.
Okay.
My lord, Lordship, no, I have to, my lord, submit on that, my lord. Case law of the Supreme Court also there. If the party is not added, is properly, my lord, no effective order can be passed. So Lordship, can you fix it on Thursday, my lord? I'll pass the judgment on that also. I'll file a written argument also. Thursday, my lord. Only at that point, my lord. That is required to be decided, my lord. That
Then
point
we
is required to be decided
added,
first.
added him the party by
My lord, it is
amendment.
not like that way, my lord. They have to submit the application, they have to edit, my lord, they have to change the cost title, then it can be.
Yes,
my
my
lord.
lord.
Not
We'll
like
do
that, my
that.
lord.
We'll do that. Part.
I have to argue on that point, my lord.
After the matter was heard, presence to rahega, due to presence. After the matter was heard at some length, and when court had taken up the matter, this court had taken up the matter for disposal. The learned counsel appearing for the Mr. J. Sutia learned counsel appearing for the respondent number 2 has raised an objection on the maintainability of the writ petition on the ground that the Karbi Anglong Autonomous Council has not been arrayed as a party respondent in the writ petition, and therefore no orders can be
No
passed.
effective order.
No effective orders qua the Karbi Anglong Autonomous Council can be passed in this proceedings. Full stop. He has submitted that he would be placing judgments to support his contention and also provide his written arguments on the issue. Is this matters again on the 25th of November 2025, enabling Mr.
Can it be
Yeah.
28, my lord?
On the
28,
8,
8,
28, no,
28.
on the 28th of November 2025, to enable Mr. Sutia to file his written arguments and the case law sought to be cited by him. Yes, Mr. Gogoi. You have filed your affidavit in opposition and you have taken up the ground of,
My lord, in the affidavit, my lord.
No, my lord.
What? That point is, my lord, law point, my lord. We have said that the Karbi Anglong Autonomous Council is constituted through and so in paragraph 2, my lord.
yes.
My-
Oblige, my lord.
এখন ফেরত
I'm appearing for the. I'm appearing for the bank in this case, my.
Yes.
Punjab National Bank.
Hmm.
Just, my lord, there is few documents was placed across the bench.
Hmm.
Last occasion
Hmm.
by the PF.
Hmm.
Because this is matter relating to few gardens in the state of Assam that a RFP was floated by the ATCL, Assam Tea Corporation Private Limited. So on lease for a period of 30 years. So out of that, one packet, Sipsagar, there were 2 gardens in Sipsagar. So one of the lessee participated and ultimately he got these 2 gardens. Now, before getting garden, he has to get financial help from the financial institution. So they said that you have to approach because there is huge money is involved. Ultimately, they approached us, the Punjab National Bank, and we decided to finance them. And accordingly, finance was made. 4 crores is in respect of cascaded facilities, and 3 point something was in respect of 2.75. 2.40 was in persons to term loan.
Okay.
Now, accordingly, this was period of 30 years, but ultimately he could not run the garden. And after 1 year, he could not run the garden. PF dues has gone up. So he said, you pay up the PF dues, authorities. He was not paying. Ultimately, that garden, they decided to put on auction, that garden. And accordingly, it was sold by an auction and the sale proceeds was deposited minus the PF dues, it was deposited with the ATCL. Now we came to the court by virtue of a writ petition. We said these are the money, public money is involved. One amount of money which is term loan and which was directly paid to you, because there was an agreement saying that you have to pay directly the term loan to the ATCL. We paid term loan, so these are public money. Ultimately, whatever the PF dues are due, PF dues, that will be minus and you pay the amount to us.
Yes.
This is a public money. So this was one argument, and the matter was this way, that way, affidavits were filed. And the last, they argued, the AG appeared in this case and argued that bonus has to be paid to the employees. Bonus. Now, we object and we said that bonus can be paid 8.33, but not 20%. Because these are all loss-making gardens. These not profit-making. So ultimately, they decided to withdraw it. And what we have been told, the amount which is lying with them, because bonus is a separate already under a different statute. So I think they have paid the maximum 20% profit. Now, the court said on the last occasion that you file one table before the court. What is the amount that is lying with them? So PF comes and across the table, they have a few papers were handed over.
I do not find that here.
2 papers were handed over. Loose paper were handed over. 2 loose paper were handed over. I think they should come and file an affidavit in this case, Mile. We also know.
Has not been tagged here as.
Yeah, that's the
Usually
problem.
It comes as a mark as X or something, but it
Yes.
is not here.
My lord.
Oh, yes.
Yes, your lordship got it.
Something is.
Something detailed regarding sale
Date
proceeds
and
of.
events is, no, this is date and event.
Yes, this is 22/9/2025. Some 2 loose paper
No signatures. This is one paper, 22/9.
or 2/9.
This is prior to.
22/9/2025. And one is 18, 22/9.
24/9 order is there.
Yes, on the last date it was handed over. 24/9 was the, if you see the order, kindly see the order that has been passed on
There's not kept-
24/9. My lord will kindly see the order of 24/9. It
Same are
reflects.
kept record.
Yes. If your lordship sees the order of 24/9/2025.
Is saying that the same is kept on record. IA কিখন আছে নেকি? So
IA 3207.
IA quickly নেকি? So
3207. Tate,
do you have a copy of it again?
my lord, your lordship can take the order copy details. Order.
The order simply says that it is kept on.
By way of an affidavit. That will be proper.
because
Whatever
then we
amount
will
is lying, that will be on record. Because we are also claiming that sale proceeds, whatever is now lying with the authority, should be given to the Assam Tea Corporation Limited, because those are our tea states. That was leased out to the private respondent.
Ah.
So that is our claim.
So the
Against the
private
claim-
respondent took
Is that-
the gardens on lease.
Please.
He could not give the PF.
Yes, he was a default.
He could not pay the PF, so that
They took over the
the gardens were auctioned because of the failure to pay
during the
PF
pendency, the sale auction took place. During the
of the writ petition. Now the PF has been paid.
They realized their own part.
So
Now,
that has
whatever
we will
balance
say that
amount
that is paid.
lying with them.
Huh.
Now, during the pendency in 2024, we are supposed to give the bonus payment for the year 2023. So that was released. The Honorable Court has made it subject to the outcome. In 24, we have released in this puja. So now whatever balance is lying with them after these 2 deductions, they will have to place it by an affidavit. Because we are also
But whether that money, whatever is lying with them, whether it goes to them or
Yes,
them, the
that's right.
quantity will not make any difference, will it? Whatever quantity it is, it
Yes.
will not make a difference while deciding
they
the
are
issue
not
whether it
eyeing-
belongs to him or you.
No, that's
they are eyeing on that money because their bank loan was also not melodium. By the
bank loan was because ultimately the lease period, lease amount, term loan, which is paid directly to them, it is with them.
No,
Because of 30 years,
different thing.
now they could, no, you are utilizing, you are taking, there is a money which is now lying with PF due, PF authorities, man. That's why let them come
Yes,
with an
file an
affidavit
affidavit, man.
indicating what is the amount that is lying with them,
Yes.
lying with them.
You
Because
are a
we-
respondent.
I'm respondent number two. Assam Tea
So
Corporation.
you are raising a counter claim.
No,
in
no, not a
plea
counter
petition.
claim. No, that lordship will decide because we are a party, we will definitely object.
But you can only object to the extended whether the money should go to
Go
him
to
or not.
them. Now, if it is no, it doesn't go to them, automatically it will come to us because they won't, my lord, they cannot retain it. The state is not there.
Unless you make a claim before this court.
That lordship will decide
My lord,
on that point.
what I feel that they should come with an affidavit.
Yes.
The
it
PF
has been
authority.
submitted by the, it has been submitted. Mr.
Uh-huh.
Both respondent two and my lord, the Provident Fund Authority will file that. The state also, my lord, the tea corporation will also file the affidavit, what exact amount we have now paid as bonus
That's
from the sale proceed, which we have acquired from them. Both will file, respondent two and respondent four need.
Eto order লিখিলে same are kept with the records. Which records?
There are two, my lord, there are two read petitions, probably the next one.
Oh, yes. It is in the eye.
Yeah.
It is in the eye. Sale proceeds.
One is 18/9/2000.
18/9, yes, these two are here with the eye.
Two gardens.
Ah.
There are two gardens.
So what you can do is you can egita yat eye bandi those. Return dia বুঝবে the eye order লিখতে same are kept on records. এটা তা কপি টাকা খুঁজে তুমি এই তোমার জেরক্সে ফেললে কি হয়? Okay. Itu collected to reply the paper. I is disposed of. I is disposed of.
Yes.
Then the disposed. Itu item 9 of. এখন 9 or হয় এখন 8 or 10 or হয় কাগজ। But Mr. Didas done a senior hearing for the petitioners assisted by Mr. A. Ganguly. Also heard Mr. P. Gogoi. Huh? For respondent number 2. Give your attendance for whichever response. It has been submitted by the learned counsel for the parties that an affidavit from the ATEPFO,
Respondent number 4 and 6.
which is respondent number 4 to 6.
4
Huh?
and 6.
4 and 6 would be necessary for proper adjudication of this case in as much as it is the respondent number 4 and 6 who can now clarify as to the amount which has been utilized and the amount which is lying with them after the tea gardens in issue had been auctioned. Although some information was provided by way of submitting the instructions to this court in the interlocutory application, it would be convenient if the respondent number 4 and 6 file the affidavits. Allowing 2 weeks time to file the said affidavits. List this matter again in the second week of December.
No, it will be, there is some urgency.
Ah.
If it is not inconvenient to your lordship and my learned friend, can it be fixed on 28/20? Because this money, my lord, one after another, ultimately will be empty.
On the 20th
Of
of
November.
November 2025. Full stop. Parties to this writ petition would be at liberty to have their instructions and file affidavits if
One
necessary.
affidavit, I will also file on behalf of respondent number 2 as to what amounts we have paid as
Yes.
bonus for the year 23 and 24.
That is what I said, parties to the writ
Only
petition.
4 and, lordship has said 4 and 5.
That is first part.
Parties.
Thereafter, I said that parties to the writ petitions would be at liberty to
Yeah,
file
yeah,
their
yeah.
respective
Yes.
affidavits in the matter to facilitate adjudication at an early date.
Deeply obliged. Deeply obliged.
Yes. Yes.
But they have to file an affidavit, my lord. We were supposed to file a response. Nahi diya.
Who has filed an affidavit?
Affidavit are signed, my lord. Only thing, my lord, there are 2 or 3 vernacular, my lord, annexed. I need to transfer.
But he has received it with the vernacular.
No, I have
No,
not
no, no.
received. I said, my lord,
We
within
are
this
supposed to
period,
file.
he was supposed to file and I was supposed to file my response.
Ha.
So
Nothing
I
has
will
come up,
take
my lord.
Time till, my lord, Monday. Lordship will fix it then next week, my lord, any day, it will be on deck. I assure.
Mr. B. Gogoi, learned additional advocate general, has submitted that although the affidavit has
On
been
behalf of
prepared
your
for-
respondent number 2,
although the affidavit on behalf of the respondent number 2 has been prepared and is ready for filing, he needs a little accommodation to translate the annexures which are in vernacular and file the same.
For 14th Monday file करने में reply file कर दूँगा.
Allowing a week's time to Mr. Gogoi to file the affidavit and allowing you want to file a reply.
Yes. 3 days will sufficient.
And allowing some further time to the petitioner to file their reply to the said affidavit if so advised, let this matter be listed after 10 days on a date to be fixed by the registry.
Can I pray for a fixed date, my lord?
The difficulty is we are filling up all
I
the
understand,
last
but-
week of November. I try to fix a date, it will come up somewhere in the end. If we say on a date to be fixed by the registry, they can see what matters can be taken up and they can fix a date for your opinion. I can fix a date on matters where already we are on a full board.
I understand.
It come up somewhere in the end, it's 2024. If we leave it to the registry, they'll find out where it can be fitted and they'll fit.
Everybody is
It is
left
your-
out at times, my lord. But because we are in a precarious position, my lord, that's the difficulty.
Why?
The building has been burnt out, my lord. It is under the order of demolition.
Hmm.
And my lord, lordship has issued notice on the stay prayer also, my lord. Still intact, my lord. We are losing on both hands, my lord.
What is the building about?
Well, it was a commercial shop, my lord. Fire had broken out.
They are not allowing you to rebuild it.
No, because they say it's not feasible. What has,
To build a fresh one.
no.
Regarding
What,
the
my lord, the
renovation
structure is so, my lord, only retrofitting is required in 2 of the pillars. We made our own assessments. My lord, the PWD engineer goes, he
Business-
sees visually and he
Business-
says it's not
business
fit.
establishment. Visual is enough for them. One person stands down beneath there,
I understand.
thereafter no
But
vision
we-
at all.
We have got 2 reports. There is an order by your lordships, my lords. They had to again take a decision. This has all not been taken.
We have said after 10 days on a date to be fixed by registry.
My friend can serve me immediately, my lord. I can by that time.
Lordship, I will serve you.
He is good at translating. Give him the vernacular, he'll have his translation.
Deeply obliged, my lord.
Yes, you were praying for some time to file your reply.
Yes. In item number 15, madam.
What about 12?
We have filed, madam, all the affidavit, except 15, madam.
So why can't we take up 12?
My lord. My lord, all the tax matter, tax
Ah,
matter.
So
and
whatever decision comes in 12, followed in 15.
No, my lord. Because.
Then we detect them, we separate them, and we listen to 12 separately.
Because all the cases arises out of, my lord, one case, my lord.
Yes.
Which was initiated in the year 2012. my lord.
That is item
And
number,
My lord, this item number,
which will be item number what?
my lord, item number 14.
14.
Yes.
So why don't we take up 14 and decide it?
My
If the
lord.
pleadings are complete.
My But my lord,
Huh?
one problem is there, my lord.
What?
My lord, already senior is engaged by the petitioner, my lord. In
Yes.
item number 14, my lord.
14.
Yes, my
So
lord.
we don't take up 14, we'll take up 12.
Because my lord, 14 is, main case is involved in item 14.
14.
And other case, there is no any relation, my lord, because my lord,
In other cases, there is no relation. We
Rela-
separate out 14, we'll take up the others.
because my lord, in the review petition already included those dark number, my lord. Initially, the case was filed only in respect of dark number 31.
So if we
my
take
lord.
up the other cases, just listen to us. If we take up the other cases,
Yes,
if we come to a finding that those dark numbers in those petitions should not have been decided in the review, therefore the review order qua those dark numbers are set aside,
yes.
your 14 is still intact. Why can't we finish 12 and 13? We go one at a time. For if your ground is that the dark numbers which were not originally before the board
Yes, my
had
lord.
been decided by the board in a review without notice
Yes.
to you, we will set aside that portion of the review.
My
So
lord,
those dark numbers will become safe,
my lord,
can be disposed of,
yes. But
and you continue your fight on the ones where the dark numbers were originally included. If we come to that conclusion that they should
yes,
not
my
have
lord,
been
this is,
included,
yes, my lord,
and if we come to a conclusion that they could have been included,
my lord,
then whatever happens in 14 will follow suit.
my lord.
Yes, sir.
My lord, I'm there in the matter, my lord.
Ah,
They filed one affidavit today.
ah, who?
They.
Ah,
Item number 15.
15.
Hmm.
So Lordship will take up this matter, my lord, on Thursday, my lord.
No, it is difficult in the month of November now.
On Thursday, my lord.
On November, it is difficult.
My lord.
On November, then other days are difficult. Today,
8, my lord.
today everything has been almost mentioned, all the hearing matters mentioned and all that, we have time. So what we were suggesting is this. He made a submission that the land included, that land involved in item number 12
14.
and 13
And-
were not there in the original order passed.
Yes,
In the review, they came to be included.
yes,
Now, whether in a review they could be included or not, if that matter is argued out, 12 and 13 can be disposed of.
my lord, 15 also included
15?
in the review.
What remains is
In fact,
14,
this is-
which is the original DAG under
All
involvement.
the cases, one order is there. ma'am.
So that is what,
Yes.
if that order could not include 12 and 13, inclusion of 12 and 13 goes without touching the merit of that order, whether the order is correct or not. Whether the order is correct or not, we can have an argument on item number 14
14, yes.
at a later date when his senior is present.
Well, my only thing is that, my lord, today's, my lord, because they are always my lord, taking time and they last affidavit they file it today.
Mm.
So, Lordship, I would just, on 6th, my lord, because today's fourth, my lord, day after tomorrow, my lord. For final disposal, my lord. And the matter,
6, 7,
6 or 7.
6, 7, there is no possibility. 10 to 22, I don't know. 10 to 21.
Let it be on 6 months, we'll try, we'll take a chance, my lord.
You can have the second week of November, that is the coming week.
Yes,
Or
then
the
11th,
third
my
week.
lord.
Hmm?
11th.
We are not fixing a date. We'll say listing the next week on a date to be fixed by the registry. They'll look into where they can accommodate. That is what
But
we've
then
been doing.
there's, because this November month, my lord, I have a traveling lot, my lord.
Uh-huh.
I have lots of traveling, my lord.
Which one?
November month, my lord. So if it's
No, that
taken
is what, if you are here on the next week,
next
10,
week, my lord,
11, 12, 13, 14. they will
next week,
fix
my
it.
lord, for 12th, I'm out, my lord.
Ah. We'll say on a hearing day, then it will be either 11 or 13.
I'm out, my lord. From 12th, I'll be back on 15th, my lord.
Then after 15, on the next, the week thereafter, we can on a hearing day. 17 to 21, choose. If you are here from 17 to 21,
20, my lord, then.
Huh?
20.
it has been submitted that an affidavit in reply has been filed today by the petitioner in item number 15.
15.
Give the WPC number, don't write it. The same is not yet on record, full stop. Mr. J. Roy, the learned senior counsel, appearing for the respondents in item number,
All the
all the items, comma, assisted by Mr. So-and-so, has submitted that he would like to go through the affidavit file today, and the matter can be taken up for disposal at a short date, full stop. List this matter again in the third week of November 2025 on a hearing day for disposal.
interim is there, madam. All the cases interim is there.
Interim orders passed earlier shall continue till the next date of listing.
All the
We have said on a hearing day on the third week. So that will come upon 20th.
My lord, the problem is that, my lord, this November, my lord, there's a frequent traveling, my lord.
No, that is what I said.
On
From
20, my
17
lord,
to
then
21.
I'm prepared for do the matter, madam.
Is the matter again on 20? 20 November.
20. My lord, item number 2, my lord, my lord.
Of lord.
system. This will take, my lord, some time, my lord. This
That is today what we have at our disposal. Time.
Yes.
Time we have at our disposal today. Yes.
Lordship will be pleased to fix another date for this matter. Actual matrices are involved along with legal issues, my lord. It will take some time.
That will take time for you to explain what is court to absorb. Which is the suggestion.
On my part to explain, my lord, with all humility.
In fact,
my
my lord,
lord.
pleading has been completed, my
Yes.
lord, and they have filed a last affidavit, my lord, along with the report. My lord, my contention is that, my lord, that report is not up to date, my lord, that because he has to take instructions. My lord, I will just,
When was the report filed?
yes, this is filed on 19/5/2025 by way of affidavit, my lord. And lordship may peruse, but of course, he is, my letter friend take instruction on this matter, my lord, then matter can be resolved at the earliest, my lord. Page 177, my lord.
Is there any urgency in the matter? No.
No urgency because last month, 2004, my lord, it has to be paid compensation. He has not been paid. There's no urgency as such, my lord.
Page 177,
Seven,
you are
ma'am.
saying?
This is a, my lord, calculation they have made.
Hmm.
My lord, they has to furnish the compensation statement action per Form C that they have not complied with. My lord. Now here, we cannot figure it out. What is the amount of interest, how much, how many interest paid for how many years, my lord? Nothing is there, my lord. Neither the tenant is there, neither that statement has to be there, my lord. Proper statement as per Form C of the regulation.
This was filed by respondent number 7.
Respondent, my lord, ADC, I think, filed it, my lord.
Huh?
This has been filed by land record assistant, my lord.
You have, this has been filed by respondent number 7. And you have filed a reply to the respondent
Yes,
number
yes,
7.
yes, yes.
So what more is to be done with respondent number 7? We'll simply say pleadings are complete. List the matters in the.
My letter friend in the meantime can take
Heard
instruction on
Mr.
this.
J. Roy, learned senior counsel, assisted by Mr. So-and-so appearing for the petitioners. Also heard Mr. R. Borpujari. Also heard Ms. P.R. Mohanto appearing for the respondent number. Okay, ako P.R. Mohanto kataje kar.
4 December.
Also heard Mr. R. Borpujari, learned counsel appearing for the respondent number.
My lord, respondent number. Sorry, my lord.
All the respondent.
My lord, respondent number 2, 2, 3, my lord.
2 and 3. You are appearing for Mr. Mr. G. Bokalial appears for the respondent number one.
One, my lord, then my lord, 4 to 8.
Who,
4
Mr.
to 8.
Bokalial will appear, 4 to 8.
4 to 8, yes.
Full stop. It has been submitted that the pleadings are complete in the matter and the matter may be heard for final disposal. List this matter again on, yes,
Um, 4th of December is Thursday, my lord, subject to my lord's convenience. 4th of December.
4th of December 2025 in the hearing column where an attempt will be made to dispose the
This first, yes, yes.
2016.
Yes. They filed
In
affidavit.
fact,
and
We could have tried today.
2016, they have been litigating since the year 1975.
No, we will read it as 2016. You have not been paying them.
Yes, my lord, my lord, I take it, my lord, I take it.
obliged, my lord.
I'm so obliged.
With pleasure, Lordship. My
Yes.
friend has taken instruction,
Hmm.
if the idea that your Lordship had given on that day, that he will sign an undertaking as far as the amount amount of deposit under hold is concerned, that will suffice.
He had to submit bank guarantee.
Undertaking how?
Okay, bank guarantee.
A bank guarantee, he submits a bank guarantee. Yes,
Counsel for Reserve Bank, Lordship, he is on late, Lordship.
yes, yes,
He has, he is on late, Lordship.
yes. What has the Reserve Bank to say on this?
Lordship,
No, it is only between State Bank now that is operator.
he's
Newspaper State Bank. The only thing is that
Reserve Bank is coming, huh?
only thing, my lord, I think I should point it out to your Lordship. The other
Yes.
day, your Lordship put me a query
Hmm.
regarding the amount, whether I claim any ownership of this amount or not. That was your Lordship's query.
Hmm.
If your Lordship will kindly come to page 31.
31.
Yes. The statement of account is annexed in annexure 5.
Hmm.
Now, the transactions, my lord, that had taken place unauthorizedly, which is said by now by the bank, that was on 6th and 7th of July. Page 32, your Lordship will kindly see the transactions. These are dated 6th and 7th of July, by which some amount had come to my account and it was withdrawn. Now, bank had put a hold on my account on 12th of July. That is my case. Now, if your Lordship will kindly come to page 34,
Hmm.
page, page 35, your Lordship will kindly see the entry number 5th.
Entry number?
Fifth entry, 49,255.
In
Page 34, 5th entry. Well, it is not,
yes, 49,000.
this 49,255 was my salary. It has come from Dhubri,
Hmm.
that your Lordship will kindly see. Now,
Yes.
thereafter, the certain entries are there. Money has come and money has also gone out of it. I don't claim any ownership over this money. What I am on is this, my lord. If your Lordship will kindly see page 35, from 18th August onwards,
Hmm.
18th August onwards, whatever money has been credited in my account,
Hmm.
these are my salary.
Hmm.
And practically bank has now, before 18th of August, the balance standing on my account was rupees 302.48.
Hmm.
Rupees 302.48. That was the balance standing on my account on 12th of July.
Hmm.
So after then, that is the date, my lord, when the bank put the hold on my account. Now, after 12th of July, whatever money has been credited to my account, my lord, the bank statement, it is a statement maintained by them. I've only downloaded it from my account ledger in the website.
Hmm.
These are all my salary. So the money which is standing on my account after 12th of July, my lord, that is certainly my money. Before that, my lord, whatever amount, they will cause an inquiry. Whatever amount has come and gone, if it is not my money, I don't claim any ownership to it. And that's why, my lord, I have,
As of today,
yes,
this writ petition had been filed.
Yes,
because they are putting a hold on your account, not allowing you to withdraw or deposit money into the same.
yes,
And by an interim order of this court, the salary was being deposited into your account and you could withdraw the salary amount. Whatever else was there in the bank,
yes,
it remained.
it remained.
So on the date of the filing of the writ petition, what was there in your account?
On the date, well, the writ petition was filed on 6th of March 2022.
6th of
March 2022.
22.
Yes. And the interim order was passed. The interim order was passed on
29 is also your account.
25th.
Page 39. It shows a balance of 5,31,000.
Yes.
Then page 40 shows a bank balance of 6,47,000.
No, this 6,40,000, yes.
After all your salary and everything is there,
Yes.
that is what it should.
On an
you are
average,
not
Milord,
allowed to touch anything of that part of the money, save and except what was coming into your account as a salary after the interim order, and you are allowed to withdraw the salary.
yes.
Now, since they have raised a issue with regarding some other few lakhs, how much
Yes.
was it?
3,25,000.
3,25,000. If you give them a bank guarantee, you use your account as you want to. If they have anything in law to claim that 3 lakhs rupees from you, 3 lakhs odd rupees from you, it will not be by way of an execution, it can be by way of a bank guarantee.
Yes.
You challenge it wherever you want to, if you can get a stay and all that.
Yes.
We
If
can
if
close
they
this
want to,
writ
if the
petition.
only thing is that if they want to invoke the bank guarantee, Milord, they will put me on notice.
Simple notice.
Yes.
If a bank guarantee allows them to give you a notice or requires them to give a notice.
Well, that is only a,
Bank
that,
guarantee does not require that to be done.
that is I am.
So therefore, you will have to take up your own measures to see that the bank guarantee is not invoked.
Yes.
That will be upon you to see.
Yes, yes.
That the bank guarantee is not invoked, that orders are not passed to your detriment by any forum. That will be upon you. That will be not upon this court or for them to see.
Yes.
They will wait for an
But
order.
the why I am showing these transactions, Milord. 12th July was the was the date on which they put on hold on my account, and all the fictitious transactions took place prior to 12th July, not thereafter. After 12th July, whatever money has come to my account,
Yes.
either through my salary or some deposit made by some of my relatives, they were holding this amount only as a guarantee to the money, toward the money which they have paid to somebody else. And because of the interim order which was passed on 25th of May 2023, I have been allowed to withdraw my salary from this account. But in the process, Milord, before 25th of May 2003, some money, usually Milord, the money was deposited because that is the salary account I maintain.
Other money might have come in.
Yes.
Your own other money might
Yes.
have come in, which you may have a right to use as
So
of today.
approximately, Milord, it was a sum of 50,000 rupees per month, my salary, on an average, Milord. So even if is deposited for 8 months, Milord, it makes a sum of rupees 4 lakhs.
Yes,
That is
RBI, you are paying for the RBI? Yes.
We are concerned about
What we have, what transpired on the last, although he had submitted that I gave the idea, I did not give the idea. What had transpired on the last occasion was the dispute is with rupees 3 lakhs odd. Bank account is his own. Stopping a bank account, allowing him only to withdraw the salary is not sufficing anybody.
Well, that order has been modified by the IA order. He has been allowed to operate his account other than the amount 325.
So now what has been submitted or instructed by the petitioner to the council is that they give a bank guarantee. They use the account as they use in the usual process. You have the bank guarantee with you. Renewed whenever you need to.
My learned friend.
So they would keep the bank guarantee. Some official lawful orders which they can execute for that amount to be recovered from the petitioner. They have the bank guarantee in hand to do so. And otherwise, why should the bank
Your Lordship.
account be put to any restriction for that matter? It's a salary account. He may use it for taking a loan, he may use it for his education of his children. So many things can happen with that loan.
Keeping the interest of the bank alive.
That is why the bank guarantee.
And the other part, this prayer 93,000 has been siphoned out from his account.
Hmm.
He alleged that he has complained before the RBI. I have written instruction from RBI that he has not raised any objection, any complaint. That is my
No,
limit.
the fate of that complaint with the RBI,
Well,
he will take it up with the RBI. You have to take it up
Yes.
with the RBI,
Yes.
whatever is the fate of that. Because last occasion, if I remember correctly, the date had exceeded. You
My
did
lord.
not make it within that time frame. The
Yes.
date had exceeded.
Yeah. It will be considered in
Some 3
accordance
days
with
or 5 days, they had
Yes,
make it. It
7.
was done on the 9th or 7th days,
Yes.
something like that.
it will be considered in a terms of the.
Milord, if it can be made like this, Milord, subject to your lordship's approval, the petitioner will file a representation before the bank and along with the bank guarantee also to the state bank,
Hmm.
narrating the transactions and his stand. Bank will take a decision, bank guarantee will be with them to invoke it at an appropriate point of time, and Reserve Bank will look into the matter as to whether this money which was illegally siphoned out of my account, what will be the fate of that complaint, that they will decide in a,
terms of the guideline,
Yes, yes.
Of, October, perhaps it is 2017.
that they will take a call.
That criteria of 7 days, 3 days, that will come.
No, that day we have already overstepped. We can't dispute that. But at least you can look into it.
If you give a decision to him, that decision will be subject to
My-
whatever other avenues of law he can follow up.
Yes.
So we dispose it of with
Yes, yes.
consent.
No, your lordship. In fact, our claim is 4,35,000.
Hmm.
So
We are disposing it of with a consent that he would be allowed to operate the bank account, subject to his furnishing the bank guarantee of
325.
325, which was the transaction in his account. The other man's claim may be 4 lakhs, we do not know. His account had a transaction of 3 point something.
3
So he'll take a guarantee for that.
he will submit.
What I
What
have
is?
found, my lord,
Your 4 lakhs claim or whatever claim
what I have found.
beyond us. Huh?
That 4,35,000. I have gone through that
Statement.
email, my lord.
Hmm.
That in his account 325 was credited,
That is what I was.
and one other person.
So
that
therefore, he will take a guarantee for 325. The other 4 lakh or not, whatever the claim of the bank is, we are not saying anything on that. We will say that fraudulent transactions of amounting to rupees 3,25,000 had taken place from his account, to which a bank lays a claim that it can be recovered from his account,
My,
to facilitate and on the consent of all the parties. He produces a bank guarantee for that amount. Bank agrees to let him use the salary account to his convenience in accordance with law. And any representation he makes to the RBI or the bank regarding the transactions,
it will
the
be considered as a-
representations will be disposed of
in a-
within a period of 45 days from the date of receipt in accordance with the rules and regulations as applicable.
That will serve.
Consent is that we are disposing it of.
My, yes.
To that extent, I am asking the consent.
And the question of one line, if your lordship can add, the question of invoking the bank guarantee will come to them only after they have.
After they have some lawful or
Yes,
legal orders
yes,
entitling them to invoke that same bank guarantee.
yes.
That, yes,
Oblige.
but Mr. We'll need all the names. Huh? কি ক'লে? এছ দত্তটো জানো বাকী গোটেইকেইটা নামটো একেলগে লিখাই লওক কোনজন কাৰ কাৰণে ৰেচপণ্ডেণ্ট নাম্বাৰ লৈ লৈছে ন appearing for the respondents, no? With the consent of the counsels for the appearing for the parties, comma, this matter has been taken up for disposal. Disposal, full stop. This writ petition was instituted in the year 2022 by the writ petitioner being aggrieved by the action of the respondent number by the being aggrieved by the action of the respondent, namely the State Bank of India, in not allowing the petitioner to transact his account number 11855646450 held by him at the State Bank of India, Bagribari branch. No, what is your account number? I
Two
gave the-
account, madam.
Two accounts have been frozen.
Yes, madam, two account. One is salary account and one is savings.
Now, what are the numbers?
3022659372
A little
is the salary account.
maintained at the Dhubri
At
branch.
Dhubri branch.
And the other account?
That other account 118556464650 at Bogribari branch.
Which is the savings bank. The cause for the State Bank of India authorities to freeze the account of the petitioner arose when certain allegations were leveled that the accounts of the petitioner, as stated herein above, were involved in making fraudulent transactions by which money was deposited into those accounts and withdrawn from the same. Full stop. Such money was alleged to have been obtained by fraud from unsuspecting victims. Full stop. Where is that order of the
Ombudsman.
Yes. The case of the petitioner is that
Page
it was-
69.
it is the case of the petitioner that it was at his instance that the fraudulent transactions were brought to the notice of the bank, and that he had also lodged an FIR with the appropriate authorities to investigate into the transactions which were being carried out in his accounts without his authorization or knowledge. Full stop. He had in fact made an application to the bank to not to allow any transactions in his account till the fraudulent, till the unauthorized transactions were investigated into. Full stop. In the meantime, it appears that the victim of the transactions, the victim from whom the said money had been fraudulently acquired by some person and who had used the bank account of the petitioner for committing such fraudulent transactions, has raised the issue before the banking ombudsman,
Ombudsman.
before the
Pradesh,
banking
UP.
ombudsman at Nainital, and certain orders had been passed by the learned ombudsman whereby it was directed that the victim whereby it was directed that the State Bank of India would remit rupees 4,35,000 into the account of the complainant before the ombudsman. Full stop. When all transactions in the accounts of the petitioner herein had been denied to be allowed by the State Bank, he approached this court praying for appropriate relief as quoted in the writ petition. Full stop. The counsels for the parties contesting the claim, that is the respondent number 3, 4, 5, and 6 have filed their respective has filed a common affidavit in opposition, to which the petitioner has also filed a reply. An additional affidavit and reply had also been filed by the petitioner on 16th of March 2023. Full stop. By an order dated, where is that salary order?
23rd of May 2023.
Just
23rd of May 2023. 25th of May 2023.
25th, it's, was it in an interlocutory application?
IA 210.
Huh? Application.
IA 210.
By an order passed on 25/5/2023 in IA civil number 210 of 2023, referred by the petitioner hearing, comma, this court allowed the operation of the bank account for any other transaction by permitting the State Bank of India Dhubri branch to retain a sum of rupees 4,35,000 into the account of the applicant. Full stop. Thus, as of today, it is only an amount of rupees 4,35,000 in the account of the petitioner which remains, which cannot be transacted upon by him, and otherwise the petitioner has been transacting from the said account. Full stop. On the last occasion that the matter was listed, after some deliberation, the learned counsel, senior counsel for the petitioner had been permitted to require instructions through the counsel assisting him. On the further course of action proposed to be taken. Full stop. Today, it has been proposed by the learned senior advocate that the petitioner would be agreeable to furnish a bank guarantee of rupees 3,25,000 to the respondent State Bank of India if he is allowed to carry on all transactions in his aforesaid accounts without any hold. Full stop. By such a procedure, comma, the learned senior advocate submits that he would be, the petitioner would be able to carry on all transactions and the apprehension in the mind of the respondent State Bank regarding the recovery of the 3,35,000 which had been deposited, which had been transacted to the petitioner's account may not be recoverable in case it is found that the petitioner was found to have been involved in the fraudulent transactions would also be satisfied. The learned counsel appearing for the State Bank of India does not object to the said proposal for deposit of the what do you call it, bank guarantee of the 3,25,000 and has submitted that the bank will not have an objection to allow the petitioner to take up all transactions as to take up all lawful transactions in his accounts once he submits the bank guarantee. The learned counsel appearing for the Reserve Bank of India also does not object to the proposal made by the parties. Full stop. In view of the above and with the consent of all the parties, comma, it is this writ petition is disposed of by directing the State Bank of India authorities to allow the petitioner to make all lawful and legal transactions in his account numbers, namely so and so and so and so. In the event the petitioner submits a bank guarantee for an amount of rupees 3,25,000 to the State Bank of India authorities. Full stop. The State Bank of India authorities would be entitled to invoke the bank guarantee submitted by the petitioner to satisfy any liability of the petitioner as may be decided by an appropriate forum of law with regard to the unauthorized transactions. The petitioner would also be at liberty to make appropriate applications to the State Bank of India and the Reserve Bank of India with regard to his allegations of a loss of rupees 49,000.
93,000.
93,000. Hmm?
93,000,
93,755, which he claims
Yes.
had been also fraudulently
withdrawn from.
withdrawn by the person who had made the unauthorized transactions in his aforesaid accounts. In case the petitioner makes such a representation, the said representation should be disposed of by the concerned authorities within a period of 45 days from the receipt of the date of such representation. Stop. Anything else?
Well, I'll make the representation to both of them.
Huh?
Reserve
To the
Bank and-
SBI and the RBI, that is what it is.
60 days because
45 days ko 60 days ka di. Or-
we'll call for the.
No issues. We have made it 60 days. And anything else, sir? Huh? Mr. Dotto has expressed an apprehension that the bank guarantee may be directed not to be invoked without following the due procedure of law. Stop. It goes without saying that the authorities holding the bank guarantee would not act except in accordance with law.
Oblige me.
The petition accordingly disposed of. 2022. Could have been done before. Yes.
Perhaps it was waiting for your lordship.
Dane dane pe. Yes.
My lord, in this case, my lord, we are appearing for the State Bank of India, my lord.
Mm.
My lord, we have prepared our affidavit sent for vetting, my lord.
Mm.
Some accommodation, my lord. Next week.
Can you tell us why the petitioners, where the petitioner cannot withdraw the pension money which was deposited in his father's account?
Because, my lord, after death of the pensioner, my lord,
Mm.
there is a procedure for, my lord, pension claim settlement. My lord, deceased claim settlement. My lord, deceased
That
claim
procedure is by whom?
by the petitioner.
No.
There is a prescription, my lord,
Uh,
for settlement of deceased claim by the nominee as well as the legal heirs. My lord, they will have to approach the branch, concerned branch, saying that our father expired, therefore, we please initiate process for deceased claim settlement.
Mm.
They did not do it. Instead, they filed a writ petition.
Mm.
Now, my lord, there are four daughters and 5 sons
Mm.
to our instruction, my lord. We have stated in our affidavit everything. Now, there are so many claimants and there are disputed and differences in between them, my lord. With regard,
did the pensioner leave a nominee?
yes.
Yes.
That is
Is
there,
there
my
a
lord.
court order saying that it will not be paid to the nominee?
My lord, nominee,
Please tell me what I'm asking you, sir.
my lord, nominee is the
Please tell me,
custodian.
is there a court order restraining the disbursal of the amount to the nominee?
As of date, no, my lord.
No.
But
Is there a clause in the bank account papers or whatever? papers that
Banking
you-
Regulation Act, my lord, I
Is
have
there
stated.
anything in law you can show me
Yes.
that if someone says that please don't pay the nominee, the bank will not pay the nominee.
Yes.
Where is that?
That is there, my lord.
Where?
I have stated all these things, my lord,
So meet
in
the
my.
regulation, will dismiss the writ petition. You don't need to file a affidavit of opposition.
My lord,
If
there
the
is a
regulation
dispute,
prohibits you
my lord,
from disbursing anything to the nominee,
my lord,
so be it. We'll dismiss the writ petition
my,
right now. But if a nominee has
nominee,
been,
my lord, in my respectful submission, my lord, the nominee is the custodian of the, my lord, the other legal case.
the nominee is the person to whom if you pay, all your legal liabilities are satisfied. That is what we understand.
Depositor, my lord, that is, my lord, the law, what the law says, my
And
lord.
any person who has a claim will make a claim to the nominee through the appropriate forum of law. Who are you to sit as an adjudicator trying to find out who is the right person to whom you should pay? Why do you hold back the money?
My lord, because section 45 ZA to
Of the,
of the Banking Regulation Act
that is
says
what I'm
about, my
asking
lord,
you.
my lord, let the
Who
matter
is a
be,
nominee and who is not a nominee?
my lord, power of the nominee, who is the nominee,
As
and
per the
how,
banking regulation.
as per the Banking Regulations Act 1949, my lord, as amended, my lord,
Please, please,
1983.
who is a nominee? Please
Yes.
change our concept. We will update our concept.
But some RBI guidelines has also come up, which is
Just
effective
read the
from,
definition of a nominee and the rights and duties of a nominee according to that. But why is it so difficult?
my lord, affidavit is sent for vetting, my lord. It's not with me, my lord. That's why, my lord, let it come day after tomorrow, my lord. I'll satisfy your lordship as to
Yes.
why, my lord, this amount has not.
You have not made any application to the bank
No, my lord.
to release it to the nominee.
No, my lord. This is
Only-
claim settlement is the first, my lord.
He had
They did not
approached.
approach.
He had approached, my lord.
Who? Where?
The nominee, my lord.
Where?
My lord, where he had,
Show us that letter.
my lord, he had approached personally, my lord. Personally.
We are dismissing the writ petition right now. Show us your approach to the bank, otherwise we are dismissing it right now. You are turning us into a banking ombudsman. What kind of a submission is that? His father expired in 2019.
Yes, sir.
Show me any document after 2019 that yes, I had gone to the bank. Show me at least the filled up form that they are not receiving. Show me a statement saying that this is where I went, this is the man I talked to. The bank does not dispute that he is the nominee. Yes, sir. The nominee is him. According to the bank record,
Yes, my lord.
the nominee is him.
Nominee.
There is no dispute to that.
That is not.
Okay.
Perhaps there is
Yes,
no dispute.
show me.
But he'll have to approach me first.
The day the pensioner expired and the bank came to know about the debt is the day the account freezes. No further transaction from the bank, from that account, except checks issued
No, my
prior
lord.
to that date. That check has to be
My
honored.
lord, what
Nothing
happened in
else.
this case, my lord, even,
Yes, take down.
even after, my lord, the
Is it
retirement of the
number?
petitioner, my lord, petitioner father,
Huh?
my lord,
1-6. Yes, take down.
his father was not
Heard,
allowed to,
mister? Huh?
his father was not even allowed to withdraw the pension amount, my lord. Even during his lifetime, my lord.
Why?
It is known to the.
How
that
do
is
you,
why,
how
my
do
lord.
we know that?
Because, my lord, here, my lord.
How do we know that? Where is that? Where is the statement from your? How do we know that your that the pensioner was not allowed to withdraw pension? Show me a statement, sir. Where did you
7,
say so?
paragraph 7, my lord.
Paragraph 7. What do you say?
All through, my lord.
Just a minute. Although his father was sanctioned with the pension, but the
Five
fathers could not raise money during his time due to objection raised by the state bank. What is that objection raised? Yes, you have any instruction on what was the objection raised why the father could
My
not
lord,
do the
the
pension?
instruction is, my lord, the life certificate was not, my lord, given to the concerned branch manager.
So now you have a death certificate.
Now-
Now we have a death
now-
certificate. So now
During
we
his
know when.
lifetime, my lord,
Listen to me.
because.
When the person has now expired, we know a definitive date that this is the day he expired. So whatever pension he was due to him till that day, that will be in the bank. The rest would have to go back to the government or whatever because it is no longer his
is-
pension.
It is with the, my lord, with the concerned department,
Ah,
railway.
Hmm.
My lord, the moment.
whatever
they-
is there in your
the-
bank.
The moment they, my lord, make a claim
Ah.
of disease claim settlement, my
Hmm.
lord, as per the prescribed procedure.
Hmm.
Then, my lord, the central, then we, my lord, transfer this amount to his account. Then only, my lord, the nominee will be able.
It is not with the railway, it is with the bank. The bank is not putting it into the account.
Now, my lord, because they did not make any claim, my lord, that is
It
why.
is not with the railway, it is with the bank. That
Really?
money has come from the railway to the bank. The bank is not putting it into the account,
Branch,
into the branch.
Yes.
Because the petitioner's father did not submit any life certificate
Correct.
up to November 2000. When did he expire?
2019.
2019.
And-
When was the last money deposited to the bank? Any idea?
My
No,
lord,
my-
instruction, my lord, I will.
No, we are not keeping this alive. District petition. It's just running around. Yes, take down.
But
What did we
fact
say?
remains they
Heard
did not approach me.
Heard
That
Mr.
is- that
Ashok
is the-
Nanak counsel appearing for the
Otherwise,
petitioner.
we would have paid.
Also heard Mr. So and so Learned counsel appearing for the.
Can be the-
Ah.
My name is. Vicky.
Learned counsel appearing for the State Bank of India, both the respondents in the writ petition full stop. The grievance raised in this writ petition is that the petitioner, who is the son of late, who is it?
Kuddus Ali.
Late Muhammad
Muhammad
Quddus
Quddus
Ali,
Right.
was not disbursed the amount lying in the bank account of late Muhammad Quddus Ali by the State Bank of India after Muhammad Quddus Ali had expired. The petitioner claims that the father of the petitioner, late Muhammad Quddus Ali, had superannuated from his services under the Indian Railways
Right.
and was entitled to a pension which was entitled to a pension.
Well, at page 15, my lord.
Page
15, 1-5. It is the PPO, my lord. Here, my lord, payable from 1/1/2016.
Entitled to a pension, comma, and as per the pension payment order issued on 15/10/2015, comma, the pension would be payable to the father of the petitioner from 1/1/2016 onwards. Full stop. As per the petitioner, certain amount of pension had also been deposited in the account of his deceased father, but the pensioner was not even allowed to withdraw money from the said account without being assigned any reason by the bank. Full stop. It is the case of the petitioner that the father of the petitioner had expired on
7/5/2019.
7/5/19.
2019. 19.
7/5/2019. And thereafter, when he approached the bank manager to be allowed to withdraw the money lying in the account of his deceased father, comma, the same was verbally rejected. And therefore, the petitioner has been constrained to approach this court praying for appropriate relief. Is that it, sir?
Right.
That is the case?
Right.
Mr. Hoff, the learned counsel for the petitioner, has submitted that in the given facts and circumstances of the case, the respondent bank does not have any authority under the law or the banking regulations to withhold money which was deposited into the account of the deceased father of the petitioner as his pension. And further, since the petitioner has been named as a nominee of the said account, comma, the banking authorities could not have denied to release the money to the petitioner. He accordingly praised that appropriate directions may be passed to the respondent bank to release all sums available in the pension account of his deceased father at the earliest, full stop. The learned counsel appearing for the State Bank of India has submitted that the affidavit in opposition has been sent for vetting, and he would be filing the affidavit in a short time. However, on a query raised by this court as to the reasons as to why why the petitioner had not been allowed to withdraw money from the account, although he was admittedly and named as the nominee for the said account, comma, the learned counsel submits that there is no record with the bank that the petitioner had made any approach as required under the procedure laid down for a nominee to operate and withdraw money from the account of a deceased account holder. Full stop. On a query made by this court to Mr. Hawk, comma, it was submitted that there is in fact no written record given with the writ petition to show that any approach as required under the regulations had been made to the bank authorities. Full stop. This is surprising. Full stop. The writ petition was initiated in the year 2022. Full stop. It is but obvious that unless the required forms, applications, etc., are placed before the bank to consider and take appropriate action for release of money lying in the account of a deceased account holder, comma, the bank would be under no responsibility to release such money or only on verbal requests made. Full stop. Faced with this situation, comma, Mr. Hawk, learned counsel appearing for the petitioner, has fairly submitted that the petitioner would not be averse to making appropriate applications and filling up appropriate forms as required under the banking procedures to claim the money lying in the account of his deceased father, of whom he had been named as a nominee. Full stop. He fairly concedes that it is only on refusal of the bank authorities to disburse him such money on the basis of his being a nominee that other appropriate forums of law would be required to be approached for redressal of grievances. Full stop. This petition is disposed of as not pressed as at this stage.
Even the petitioner may be given the liberty, my lord.
That we will do. That is why we are disposing it off as not pressed. This writ petition is thus disposed of as not pressed in its present form before this court, comma, allowing liberty to the petitioner to take such necessary steps before the bank authorities by filling up necessary applications, forms, etc., to claim the money which is lying in the account of the deceased father. Full stop. It has been submitted that some amount of pension had not been deposited in the account of the deceased father because the deceased father could not or did not submit the necessary life certificate at the relevant point of time. Full stop. It is made clear that now, since there is a definitive date indicating the death of the father of the deceased father of the petitioner, comma, The bank would also take appropriate steps to take note of the same and have the pension amount as entitled to the deceased father to be deposited into the said account, and on the application of the on an application being made by the petitioner to the bank authorities, the bank authorities would cooperate to see that any disbursal or removal as as required under the law should be made at an early date to redress the grievances of the petitioner raised in this writ petition. Writ petition accordingly closed in the above direction. It is not to your detriment, I hope. The order is not to your detriment. Let him make a.
Let them approach me. That's what I told my learned friend, my lord. Why did not he approach earlier, my lord? Instead of approaching bank, my lord,
You could have said it in 2022 and we could have closed it on that day saying that go and make an application.
After 2022, my lord. It was listed on 15th of this month, my lord, October 2025. After about 3 years. That he
So
should have-
practically it took 3 days.
3 days.
3 days.
Correct.
From
For
2022
his
to
disposal.
2023.
Yes.
Yes.
Deeply obliged.
How many matters left? Madam? Last matter.
This matter may be disposed of, Lordship, since that.
In both the cases,
Lordship, we have
So your prayers in the writ petition have been redressed.
repressed.
The police authorities had registered the.
completed.
After
investigation, we have submitted the.
Yes.
Yes.
Likhe heard Mr. So-and-so learned counsel for the petitioner. Also heard Mr. So-and-so learned counsel appearing for the, yes, you are appearing for?
I'm for respondent number 6, Lord.
Name.
A Singh, Lord.
And Mr. K. Gogoi.
I am for 1, 3 and 4.
Learned additional senior government or as the PP.
Additional senior government.
Huh?
Additional senior government.
As the additional senior government appears for the respondent number
1, 3 and 4.
1, 3 and 4, full stop. The grievance raised in this writ petition was that although the petitioner had approached the concerned police authorities at the, which police station?
Jalukbari.
Jalukbari police station with certain grievances and complaints, they were not registered in the same. Full stop. On the last occasion when the matter was taken up on
Yesterday.
3/11/2025, the learned councils were required to have their instructions on the further processes that might have taken place after the filing of the writ petition in the year 2016, full stop. Today, a submission has been made by both the parties that the complaints made by the writ petitioner had been registered as FIRs by the concerned police authorities, investigations have been made and final reports have also been submitted to the appropriate forum of law. In such view of the matter, the prayers made in the writ petition have been addressed to and require no further adjudication by this case. Mr. K. Gogoi, learned additional senior government advocate, has submitted that the complaints made by the petitioner have been registered as, yes, madam, you take into this. Huh? Have been registered as so-and-so, so-and-so, FR number so-and-so, so-and-so. What are those names?
That IO's name is, they are not required.
That is not required. Only we registered as Jalukbari PS case number so-and-so, which ended in FR number so-and-so, and Jalukbari PS case number so-and-so, which ended in FR number so-and-so. In view of the submissions made, this writ petition is closed. Now this part you don't write without affording any opportunity to the court to adjudicate the matter. Yes. Finished? Thank you.